Hi friend, welcome to the company law update. Ministry of Corporate Affairs on 27th June 2025 notify companies restriction on number of the layers amendment rules 2025. Introducing a revised form CRL-1. It is a return regarding number of the layers under section 2 clause 87 of the Companies Act. This form will impact your company structure. In this presentation, we are trying to provide a detailed understanding of these rules, focusing on the new form CRL-1, its implication and compliance guideline for Indian companies. Let's see the presentation. Companies restriction on number of the layers amendment rule 2025 notified by the MCA on 27th June and will be effective from 14th July. The previous form CRL-1 has been replaced by a more detailed version. Purpose of this form, enhancing transparency and oversight of corporate subsidiary structure across India. This is a stricter regulatory monitoring and disclosure to better govern complex multi-layer companies. Applicability of this form, who will file this form? All companies with more than one layer of the subsidiaries or companies forming and restructuring layered subsidiaries set up are required to file the new form CRL-1. Exemption provided to following types of the company: government company, first, banking and insurance company, third, NBFC, and fourth, companies acquiring subsidiaries through court-approved scheme. This type of the company are exempted from filing CRL-1 form. Key changes in the revised form CRL-1. Revised CRL form giving expanded disclosure, corporate identification number and registered office details, official email ID of the company, number of subsidiary layers as on the commencement date, and layer wise details of the subsidiaries and holding companies such as name, registration details, shareholding percentage, nature of control and structure level. Filing process and compliances. Form CRL-1 must be filed electronically and digitally signed by authorized signatories such as director, CEO, CFO or company secretary. And this form must be supported by a board resolution and submitted within 30 days of forming or altering subsidiary layers, or annually or as mandated by MCA. Non-compliance or false information attracts penalties under section 448 and 449 of the Companies Act. This will show importance of the accuracy required for filing Form CRL-1. Regulatory impact and purpose. The amendment seeks to promote transparency in corporate ownership, enabling a regulator to trace complex structure. It aims to prevent misuse of sale or dormant companies, enhance alignment with the global anti-money laundering and corporate governance standards, and strengthen investor confidence through robust governance practices. Critical implication for companies. Company will need to upgrade their internal data management system to maintain detailed subsidy information continuously and enhance disclosure requirement, increase administrative workload, but will also encourage corporate clarity and risk management. Legal and compliance team must ensure timely and accurate filing to avoid penalties and reputational risk. Key takeaways. New form CRL-1 enhanced transparency and regulatory oversight from 14th July 2025 applies to companies with multiple subsidy layer with a specific exemption. given in our slide, requires comprehensive layer-wise subsidy disclosure and timely electronic filings, essential to update governance process, internal system, and ensure legal compliance. Companies should immediately assess their organizational structure and prepare compliance strategy aligned with this amendment. Thank you so much for watching this update. In case of any query, please drop in the comments box. We will try to give a response after form is fully functional on the MCA portal. Thank you so much for watching this update.